The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to this month's webinar, the 2021 Mid-Year Employer Update, New Laws and the New Normal. This free webinar is available exclusively for our customers enrolled in our subscription services. I'm Stephanie Blicki, the Corporate Accounts Executive for Personnel Concepts, and I'm joined by my co-moderator, Leon Firestone, who serves as our Senior Regulatory Researcher.
Hello and good afternoon to all of our attendees. I'd like to welcome Jeffery Fucci as our guest speaker. Jeff, a graduate of Vermont Law School with a dual master's degree, and JD serves as an in-house legal counsel to a diverse group of corporate clients in such sectors as medicine, technology, health, food, and media. As a managing partner of J. Fucci Law, LLC, a remote law practice with offices in New York and New Jersey, Jeff provides counsel to his business clients on matters including labor disputes, employment, negotiations, anti-discrimination, workplace policies, equity agreements, non-disclosure agreements, and general consultation.
Thanks for having me, Leon and Stephanie, and thanks for the introduction, Leon. On either side of COVID-19, significant changes have been implemented or on the horizon for the American workplace. In today's webinar, we're going to provide an overview of the various types of laws being implemented right now through legislative action, agency action, and executive orders, which have the effect on which are having an effect on businesses as they return to full operation. COVID-19 is a big part of this conversation, but it's not the only part, as we also have a new presidential administration which is revising, revamping, and in a lot of cases, simply starting over in terms of the programs and policies from the past. Of course, by taking some time out of your day for a refresher course like the one you've done today with Personnel Concepts and your experts, Leon and Stephanie, we're going to help your business get up to speed with all of these changes. I'm looking forward to working with them both and to answering your questions at the end of the presentation.
Thank you, Jeffrey. We're definitely looking forward to discussing this topic with you. Now, before we proceed, we just want to make sure that everybody was able to hear and view Jeffrey clearly. If you have any audio issues, please check the volume on your computer or mobile device. If that doesn't solve the issue, just let us know in the chat and we'll work to improve the audio as best we can. Now, Leon, let's take a look at today's agenda.
Sure, and as Jeffrey mentioned, today's agenda focuses on providing an overview of the various legislative action and employment law initiatives that have had the greatest impact on U.S. employers thus far in 2021. We'll start off with the latest COVID-19 guidance from the CDC, OSHA, and EEOC addressing vaccinated and unvaccinated individuals in the workplace and essential worker rights and protections. Next, we'll cover the status of critical wage and hour law updates for employers, including wage and hour violation enforcement, implementing the updated tip pooling rule, the delayed independent contractor rule, and the federal contractor minimum wage increase. Lastly, we'll review the remaining employment laws that require employer action and workplace policy changes from various governing agencies, including updated sexual orientation and gender identity protections, revised COBRA continuation of health coverage policy, new enforcement guidelines for cybersecurity and national labor relations, and changes to I-9 compliance and onboarding immigrant workers guidelines. The webinar will conclude with Jeffrey providing best tips for employers and answering questions from our audience.
Yes, and the format for today's webinar features a series of questions that we'll be asking Jeffrey regarding critical employment law updates that have taken place thus far in 2021. The purpose of this webinar is to provide accurate and authoritative information on the subject matter herein. It does not constitute legal advice. The applicability of the laws discussed today may depend on your state, type of business, and number of employees. We recommend working directly with legal counsel on specific matters pertaining to employment laws affecting your business. Personnel Concepts, our webinar host, and our guest speaker are not liable for any errors, omissions, or changes in law.
And then we'd like to start off today's webinar by asking our attendees a question, so please participate in the poll. And I'm going to launch it now, and we would like to know, what are you most interested in hearing today? Is it vaccination and COVID-19 testing policies in the workplace? Is it essential worker rights and protections? Federal contractor minimum wage increase? The tip pooling rule implementation and delay? Or is it I-9 compliance and onboarding requirements? We'll give the attendees a few moments, and the answers are flying in. I can see one is definitely taking the lead here. And somewhat as to be expected, but please continue to vote. We've Got about 50% of the audience has voted, and I'll give it 5 more seconds. Come on, let those answers come on in. I'll close it now. And it, like I said, somewhat to be expected. Vaccination and COVID-19 testing policies in the workplace is what you're most interested in as of now. That may change as we go throughout the presentation, but thank you to everyone that responded.
Yes, thanks indeed. Now, before we begin, Personnel Concepts is offering all of our attendees our 2021 Mid-Year Employment Law Update white paper, along with today's slide presentation equipped for note-taking, which is attached as a handout right here in GoToWebinar. And then at the end of the session, you'll receive a downloadable certificate as proof of your attendance today. Also, I want to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also post questions in the question window. Most of them will be saved for the end of today's session, but those that are relevant to the subtopic being discussed will be posed where appropriate. And then at the end of the session, you'll have the opportunity to use that raise hand feature in GoToWebinar to pose a question directly to our guest speaker. With that, let's get started with today's presentation.
Thanks, Stephanie. So, Jeff, over the last couple of months, we've seen a dramatic shift in reopening guidance from national and local governments, all seemingly stemming from the recent CDC guidance on vaccinated individuals. Can you give us an overview of that guidance and its effect on workplaces?
Absolutely, Leon, and that's a great place to start because I saw from the survey that many of the folks that are at their jobs are concerned about COVID vaccinations and testing in the workplace. So we're going to talk about all of that in the next few minutes. Starting with the vaccination guidelines and the CDC guidance, on May 13th of 2021, the U.S. Centers for Disease Control and Prevention, which we know as the CDC, updated its guidance titled Interim Public Health Recommendations for Fully Vaccinated People. And they rolled back recommendations for wearing face masks, social distancing, and other protective measures for those individuals who've been fully vaccinated against COVID-19. We've probably seen a lot of that in our communities. According to the current updated guidance from the CDC, if you are fully vaccinated, you are now safe to resume activities that you did before the pandemic, to resume activities without wearing a mask or having to stay 6 feet apart from other individuals, except when you're required by federal, state, local, tribal, or territorial laws, rules, or regulations, or local businesses or workplace guidances. So in those particular situations, if you see a rule that's a little bit more restrictive, you're still required, according to the CDC, to follow it because there's probably a reason why it was implemented. And we may or may not know what that was, but certainly the people who implemented it, it was important to them. You can now travel in the United States without testing before your departure. You can now travel in the United States without self-quarantining after your trip. Note, though, that the rules for traveling abroad, they vary based on the country of destination because those countries have control of what their own bringing in of folks' regulations are. So you have to still be advised when you're traveling internationally to look up the rules for each of the particular countries that you're going to. Upon your return, the CDC still recommends 3 to 5 days after your return taking a test because, again, you're going to another place. We don't want any of the COVID virus to come back into the country. And the CDC also recommends that if you've been exposed to a person with COVID-19, you do not need to stay away from others or get tested unless you feel that you have symptoms. However, if you've been exposed to someone with COVID-19 as a result of your workplace or your living or visitation bringing you to something like a correctional facility, a detention facility, or a homeless shelter, or any other large public facility of that nature, the CDC recommends you get a test even if you don't have symptoms. So just to reiterate, despite all of the guidance being lifted, the CDC still recommends that high volume in places, certain workplaces or places that you may go, if you're in one of those, again, homeless shelters, perhaps courthouses, correctional facilities, detention facilities, anything where a lot of individuals are coming and going, you should still have a test under any circumstances. And of course, tests are available from your local clinic at this point, or you can order one online and have a rapid come your way. And those are the new CDC guidelines that have been implemented.
All right, thanks for reviewing those recent updates, Jeff. And I'm sure many of our vaccinated audience members are taking advantage of those renewed privileges. But can we also remind them of the recommendations offered by the CDC?
Sure, Stephanie. In terms of the behaviors that we as Americans developed during the pandemic, the CDC recommends that we continue some of them. And even if you're still vaccinated, you should continue to follow the guidance of the workplace you work in and the local business you patronize. If you travel, take steps to protect yourself and others, such as continuing to wear a mask on planes, buses, trains, ferries, and other forms of public transportation traveling into, within, or without the United States, and also in the transportation hubs, such as airports and major train stations that you go through. Watch out for symptoms of COVID-19, and unfortunately, we all know too well what they are: fever, cough, and things of that nature, especially if you've been around someone who is sick. Stay home if you have symptoms of COVID-19. Get tested if you have symptoms of COVID-19, and speak with your healthcare provider if you have a condition or take medications that may, as a general rule, weaken your immune system, because individuals with weakened immune systems still remain highly susceptible to COVID-19 and its variants. And there have even been some cases where the medicines that the vaccinations that have been out there have not protected all of the individuals who have weakened immune systems, are on certain kinds of medications, or have situations that kind of represent the outlying medical conditions. So if you have a chronic disease or a disease that's a very troublesome one, or you're on a lot of medications, you should speak with your healthcare provider to find out the efficacy of the vaccine and what precautions you yourself should still take. I'm sure we've all seen individuals out and about still wearing masks, and many of them certainly have reasons for doing so.
Thanks, Jeffrey. Now let's do another quick poll for our listeners. Now that we've learned about the CDC's guidance for vaccinated individuals, we'll follow up about the workplace of our listeners. So we'd like to know, and I'll launch it now, does your company currently have a vaccination policy or a policy for reporting vaccination status? Please choose the option that best describes your situation. Is it yes, vaccines are required for all employees? Is it yes, but vaccines are optional for employees? Is it no, but we encourage that our employees get vaccinated? No, we don't recommend or condemn the vaccine. Or are you currently developing your vaccine policy within your workplace? The answers are rolling in. We're getting a lot more representation and participation on this one. 70% of you have voted. Please let those answers roll in for just a few more moments here. We'd like to get as much data as possible, and I'll be closing the survey now. We got about 76% of you guys. Just get those answers a little bit faster so we can get 100% next time, but I'll share what we got this time around. 50% of you say no, they're not required, but you do encourage employees to get vaccinated. So thank you so much for those answers. I'll go ahead and hide the results for now. And Jeff, so following the release of the updated CDC guidance, and the vaccine in general, employers were left with serious questions about mandating vaccinations at their work sites. From what I understand, the EEOC released guidance answering that critical question. Is that correct?
Yes, they have. But let's back up a little bit and explain who the EEOC is and what their role is in terms of COVID-19 guidelines. The federal EEOC, which stands for the Equal Employment Opportunity Commission, has continually been updating guidance during the rapidly changing course of the COVID-19 pandemic, which is now stretched, as we know, across 2 years and 2 different presidential administrations. And the agency continues to do so with regard to vaccinations, testings, reopenings, and returns to the workplace. Throughout this pandemic, the legal rules and regulations and acceptable labor policies from employers have remained pretty consistent as far as the EEOC is concerned. The legality of such policies has generally been governed by several federal statutes, and I'm going to go over them. Let me say, before I get into them and go over some of the technical legalese, these statutes are all we consider to be constitutional protections in a broad category. These are the protected behaviors and the protected characteristics that individuals have when they go into the workplace. So we'll go over what those laws are, but when it comes to the EEOC's consideration of what workplace policies for COVID-19 are acceptable and not, it comes down to whether the people that are being regulated have some sort of protected right to do something against the worker policy. So who are those individuals? Well, they're people that are protected by Title VII of the Civil Rights Act of 1964. We know that generally as Title VII. That law prohibits employers from discriminating against individuals based on their race, religion, sex, gender identity, and sexual orientation, which we'll talk about a little bit more later, gender, or national origin in hiring, firing, or any other employment-based decisions. The second law to consider is the Americans with Disabilities Act. We know that as the ADA. That prohibits discrimination against individuals based upon their actual or their perceived disabilities. And the third law to consider is an offshoot of the ADA that's called the Pregnancy Discrimination Act, or PDA. That prohibits employers from making employment-related decisions such as hiring, firing, or promoting workers based upon pregnancy, childbirth, or related medical conditions. In terms of the vaccinations and the testing policies for COVID-19, the EEOC has determined over the past several months that employers may require their employees to be vaccinated with the Moderna, Pfizer, or Johnson & Johnson vaccines, or tested as a condition of physically returning to work, because these types of policies related to vaccinations and testing are considered generally to be safety related and consistent with the business necessity of workplaces, which, as we all know, are communal areas. However, in consideration of the protected classifications and behaviors that I just described to you, the Title VII, the ADA, and the PDA, the EEOC advises that employers may face situations where employees say they have a reason why they don't want to be tested or to have a vaccine. And in that case, there's a legal test and a process to go through. There are going to be individuals who have legal exceptions to the vaccine requirement, and those are people who have a disability, pregnancy, or a firmly held religious belief. In that case, employers are to consider providing reasonable accommodations for unvaccinated individuals. They have to look at whether or not providing such an accommodation will create an undue hardship for the business, and that's such as the business couldn't function or would be seriously impacted if they had to provide that accommodation to the worker. And then they have to go through a process for an individualized assessment for the unvaccinated or the untested employee. And that process of analysis involves looking at the duration of the risk that's being posed, the nature and the severity of the potential harm, the likelihood that potential harm will occur, and the evidence of potential harm. So what does all that mean? It means basically that when an employee comes to you as an employer and says, I will not conform to this vaccination or testing policy, and I have a reason, my reason is related to religion, say, for example, that is when the process begins of documenting everything, going through this analysis, and communicating back and forth in the discursive process with the employee to figure out, can you provide the accommodation, or is it too hard of a hardship for the business? And if you can provide the accommodation, go ahead and provide it. A good example would be an employee says, I refuse to get vaccinated, I have a religious reason. So the employer discusses this with the employee and then says, okay, we understand, we'll make an accommodation for you. You need to wear a mask to work. We'll put you in an area that's well ventilated. We'll isolate you from other employees, or perhaps another version of that, you can work from home, which many employers at this point instituted remote workplaces. Many of us are still aware of remote work situations that are going on. And since many employers adopted those during COVID-19, the test is going to fall towards that consideration being something reasonable. If you had a remote workplace policy in place before, you should definitely consider using that remote work situation as the reasonable accommodation because you did it before, right? So that's the legal test. Those are the things to consider. Those are the protected classes. In all cases, conduct an employee risk assessment, as I said, and document it. Introduce COVID-19 and testing protocols and policies if you feel that you want to have them, and make sure that those policies are equally applied to all and disseminated clearly throughout the company. A good recommendation of best practice is to make sure that you send out the information and then have your employees confirm that they've received it and read it like you do with other policies. And that takes us back to Stephanie and Leon after my overview.
Well, thanks for detailing that EEOC guidance for us, Jeff. Now, in addition to the extensive COVID-related workplace guidance we've covered so far, I'm sure that OSHA has made its presence felt as well. Could you review any OSHA standards that have affected workplaces in 2021?
Absolutely, Stephanie. In January 2021, by executive order, President Biden directed the Department of Labor, also known as the DOL, to launch a national program to focus OSHA's enforcement efforts related to COVID-19 on hazardous conditions that put the largest number of workers at serious risk, and to combat such things as employer retaliation against employees who complain about unsafe or unhealthful conditions or exercise other rights that are protected rights under the Occupational Safety and Health Act. This is called, to some extent, what does it fall under? It falls under this umbrella of what's called the National Emphasis Program. And this program has targeted goals and enforcement for how it's to affect workplaces. It includes inspection follow-ups at sites that have fatalities or documented COVID-19 outbreaks or exposures. It targets specific high-risk industries, and we've heard about some of those industries in the last 2 years. The meatpacking industry was one. Anything in agricultural was another. Anything where people work in confined spaces, such as shipping, medical, transportation. Those were all high-risk industries and continue to be. And the National Emphasis Program is also concerned with making the workplace environments and the workers in them aware of anti-retaliation and whistleblower protection programs. So OSHA has resources available so that people can report to them if they're an employee and they complain to an employer about a health or safety standard related to COVID, and they're concerned that their issues were not heard. They can turn to OSHA and they can file a complaint. They'll receive confidential treatment. OSHA will get involved, and if it is in fact found to be the case, they'll receive protections against any sort of retaliatory actions in the workplace. So to the employers out there, give your workers a day in court, so to speak, if they have an issue related to COVID-19. Let them speak their mind. Again, document everything, and be prepared that if you can't address their concern, they may be aware that they can turn to OSHA. And OSHA does have programs in place now specifically related to COVID-19 to provide them some resources.
Excellent. Nice information. Thanks, Jeff. And before we move on and address specific employee segments impacted by recent employment law updates, let's learn a little bit about the employee demographics of our audience. So we need some information from you all out there, and I'll be launching another poll. And what we need to know from this one is, of the following, which applies to your company? Please choose all that apply. Do you employ essential workers? Do you hire tipped workers? Do you hire independent contractors? Are you a federal contractor engaged in a service contract or any federal contract business? Or do none of the above apply? So please choose the option that best fits your business. And like we said, choose all that apply. Obviously, you can have all four of these. And so we have about 60% of you that have voted. We'll give a few moments here. Thank you. Those votes are flying in. And one is definitely taking the lead. We've reached our 75% threshold, and I'm going to be closing the poll, get those last minute responses in. And the results show that 58% of you employ essential workers, so a good chunk. We also have a good chunk that hire independent contractors and some federal contractors and tipped workers at workplaces as well. And for 30% of you, 31%, none of the above apply. So if once your section comes up in these next couple sections, we'll address each of you specifically. Make sure to pay close attention.
All right, yeah, thanks to our audience. So in addition to the workplace guidance that's developed in response to COVID-19, we've seen a new employee designation for essential workers. Jeff, could you go over the rights and protections provided for this new class of employees?
My pleasure, Stephanie, especially since such a large group of our attendees today indicated those are their employees. In April of 2021, the federal DOL launched the Essential Workers Essential Protections Program, an initiative to ensure that workers knew about the wage and hour laws that were in place to protect them. Again, particularly anyone who qualifies as an essential worker. This program asks the question and targets its efforts towards who the essential workers are. We know this new class of individuals now better after COVID. They include people who work in grocery stores, our shipping folks who bring stuff to us, anyone involved in manufacturing of essential goods such as toiletries or food, public transportation, medical and healthcare, and industries like that who provide essential services to us. And I think in the last few years, we realized even more how essential so many things are. It's also looking right now towards any workers that have a history of issues such as wage theft, exploitation of hours, and violation of worker protections. So DOL is ramping up its efforts against any employers who have a history of having problems. And they're also putting together and continuing to put out there information initiatives and outreach programs, which include on their website answers to frequently asked questions addressing pandemic-related workplace scenarios being routinely asked by employers and employees. They're developing, very much like today's presentation, nationwide webinars to educate workers, worker advocates, employers, and other stakeholders. They're creating and distributing multilingual materials in accessible formats, such as radio public service announcements, messages distributed throughout social media platforms, and posters in public gathering spaces, including workplace break rooms. And they've established a helpline, which I'll read slowly so everyone knows it, where any employers or employees can call to speak confidentially and directly with a trained professional about workplace concerns. And that number is 866-4US-WAGE. That's 866-4US-WAGE. So anyone who's in the essential worker category can now reach out to DOL, ask COVID-19 related questions about wage and hour issues, and any of these essential workers will be given sort of front of the line treatment as they try to get this help from the federal government, this information.
Yeah, Jeff, and in addition to the focus on wage and hour issues affecting essential workers, we've seen a lot of legislative activity addressing a vast array of workplaces and industries. As we mentioned, we'll get into the industry-specific updates, but can you remind our audience of the potential violations associated with wage and hour enforcement?
I can, Leon. I think that's a great place to start. The Wage and Hour Division of the Federal Department of Labor enforces something called the Fair Labor Standards Act by carrying out investigations at workplaces across the U.S. DOL investigators gather data on wages, hours, and other employment conditions or practices in order to determine compliance with the law. Where violations are found, the DOL also may recommend changes in employment practices to help bring an employer into compliance. Right now, the DOL is specifically focused on these areas: adverse actions against employees who file a complaint, willful violations of the Fair Labor Standards Act, child labor law violations, overtime pay violations, and also industries that ship goods in interstate commerce who are violators of any of the FLSA laws and rules and regulations. This is because the DOL has the greatest authority and easiest path to exercise their authority as a legal matter over businesses that work in national, state-to-state goods and services. Since this is a federal agency, the DOL, any company trafficking in interstate goods and services, which in the modern world is really every company, is going to be subject for scrutiny for these wage and hour violations.
All right, thanks for those reminders, Jeff. Now that our audience is aware of what's at stake, could we transition into the new considerations for employers, starting with tipped employees?
Sure, let's do it. In April of 2021, the Department of Labor partially implemented a final rule revising its tipped employee regulations and addressing amendments to the Fair Labor Standards Act. The final rule was originally supposed to become effective on March 1st of 2021. However, the DOL announced that it would delay the effective date of the rule until April 30th, 2021, saying to allow the department to review issues of law, policy, and fact raised by the rule before it takes effect was very important consideration. Under what's now become a bifurcated approach, which the DOL ultimately adopted, several portions of the final rule have gone into effect, while several more will go into effect at the end of the year. The ones that have gone into effect now, most significantly, are a restriction on employers, and this employer category includes also the supervisors and the managers, on keeping tips received by workers, regardless of whether or not those workers are being included in a tip credit. The ability of employers to not take who do not take tip credits to now include non-tip workers has become seriously diminished. And all tipped employee record-keeping requirements have been sort of ratcheted up. So what's going on now is a trend that we saw previously, which is for more protections to be in place to prevent employers from sort of dipping in to tipped employee wages, or rather tips. And also a situation where if you're a non-tipped employee, the amount of ability you're going to have for your employer to sort of put you into that pool is also being reduced. That trend was going on for several years now, but over the course of this year, we're going to see significant changes to it. As for the remaining provisions of the final rule, the DOL has proposed further extending their implementation of the rule in its totality until December 31st, 2021, the effective date of the assessment of civil monetary penalties, and the FLSA's tip credit application to employees who perform dual tasks going into effect. Employers that rely on tip credits or employ tipped employees should take the following steps in response to the current partial implementation of the final rule. They should try to review and revise their policies and practices applicable to tipped employee wages and compensation, including any tip sharing agreements impacting non-tipped employees. They should try to ensure that all financial record-keeping practices are in compliance with the law's new requirements. They should plan and be expecting periodic audits to avoid increased liability. And employers with employees who perform dual tasks, in other words, tipped and non-tipped work, or are otherwise impacted by these provisions of the final rule, should also continue to track the implementation of the rule throughout the course of this year, because the rule is currently set to become fully effective on December 31st, 2021, at which time the employers will be susceptible to civil penalties, as we mentioned. And of course, during this time, as DOL continues to investigate its rule, it may still be subject to additional change.
All right, thanks, Jeff. And in addition to tipped employees, we've also seen updated enforcement for independent and federal contractors. Can we review the recent changes that have taken place for these employee classifications?
Yes, I'd be happy to, Stephanie. In May 2021, President Biden's administration formally withdrew the Trump administration's independent contractor status under the Fair Labor Standards Act rule, returning to the former status quo test of considering the totality of circumstances when determining if a worker is an employee or an independent contractor from the FLSA standpoint. Now, I know some of our people who are listening today who responded said they had independent contractors who work for their company. I know we've talked before about how many people in the modern context are independent contractors, sometimes also known as 1099 workers. I want to take a moment to just expand a little upon this section, just in that to say, overall, what's been happening in recent years is the totality of the circumstances test has been an analysis where the courts and the agencies are looking at what is the overall impact of the job upon the individual who works their life. How much are they using this primary job for their bread and butter, and how much are they a person who has many different jobs sort of pieced together in sort of a gig economy. In the current context, there's a factors test, which is available from the federal government, and also every state has its own. But pretty much the factors test looks to such things as whether or not the employer provides the tools for the trade, they set the hours versus the independent contractor doing the work on their own time, on their own schedule, whether or not there's a formal arrangement in place, which I always recommend. Employers should make it clear with employees whether it's an independent contractor or full-time employee situation. So the paper trail is very important. And then also other such factors that are going on, such as the amount of control, the amount of direction that the employer gives the employee, or how much they're considered to be a professional who brings the knowledge of how to do the job to the job on their own. So there's also, in addition to this, the courts and the agencies also look to an economic dependability test, which is a two-factor test that looks at, as I mentioned before, how much the employee or the independent contractor relies on the employment for their primary pay, and then also how much the employer relies upon the independent contractor for an essential part of their operation. There's additional guideposts to help make this determination, and there's a tension, which a lot of these rules have right now, between the previous administration's interpretation and the current administration's interpretation. Of course, there's two political parties. They have very different views. The current administration is trending more towards bringing more independent contractors under the consideration of full-time workers. I believe that a lot of people have heard out there about some talk in California about some of the rideshare drivers and how some of the rideshare companies, without naming any names, were trying to continue to treat them as independent contractors. And as so many people were actually relying upon rideshare services for their primary employment, the courts and the agencies out in California have come down on determining that those rideshare individuals are actually full-time employees. So that trend is a good sense of where things are heading. There's a lot more consideration now of previously independent contractors, even though there's a lot of them being considered to be employees. So watch for that. It's very important.
And thanks for expanding in that section. You know, we had about 30% of our audience that do hire independent contractors, so very useful there. But what changes are upcoming for federal contractors?
Yes, Leon, I said to you before our presentation today, it's a great time to be a federal contractor. President Biden signed an executive order this year raising the federal minimum wage for contractors and subcontractors, that's anyone who works with the federal government under a contract, to $15 an hour. That's an increase that'll be significant for anyone affected by the federal contracting process. Under the terms of the executive order, all executive departments and agencies of the U.S. government must ensure that contracts and subcontracts include a clause that the contractor and the subcontractor will be paid $15 an hour beginning on January 30th, 2022, $15 an hour or higher beginning on January 1st, 2023, subject to the discretion of the Department of Labor after reviewing the Consumer Price Index for urban wage earners and clerical workers to determine if an increase correlates properly to the cost of living, and in continued annual increases as determined by the Secretary of Labor. So as of now, President Biden being in office, we can expect most likely increases to continue through at least the duration of his term, and then perhaps onward depending upon who the next president might be. In addition, the tipped worker minimum wage is anticipated to be going up as well as part of this executive order.
Thanks again, Jeff, for reviewing those major wage and hour developments that took place over the last couple months. Before we get back into some general workplace updates, so this next section will apply to everyone, pretty much everyone, let's get the audience involved with another poll. So we'd like to know, how confident are you that your workplace is compliant with recently updated COBRA requirements? Is it A, are you very confident and you've accommodated for changes based on the ARPA? You'll learn a little bit about that in a minute. B, are you somewhat confident is your HR department have recently made changes to update its COBRA policy? C, not confident at all. We are aware of the COBRA continuation change, but you're not sure how. D, this is the first you heard of the COBRA continuation of coverage. Or is it E, COBRA benefits aren't offered at our workplace because we have less than 20 employees? And we're already at 50% of you have responded. And so this is just for us to get a sense of how you guys are updating your policies on your own. Obviously, at Personal Concepts, we'd like to make sure that we are feeding you the information to help you out at all times with your HR obligations. We're just here at 66%, trying to reach 70, but I'll close it in just a few moments here and share the responses. 69, close enough. And it looks like that most of you are very confident and you've accommodated for the recent COBRA changes. So for the rest of you, make sure that you pay close attention to this next section because Jeff will be going over that in detail. And now that we are aware of your status, like we mentioned, Jeff, can you review the details of the change that took place?
Absolutely, Leon. And I'm glad to see that a lot of employers do consider themselves to be up to date with COBRA, although maybe we'll tell them something that will surprise them. What's good to see is that the COBRA updates actually benefit the employers as well as the employees. So I'm glad to see that many of the employers consider themselves up to date. One of the most significant updates we've seen recently took place to the Consolidated Omnibus Budget Reconciliation Act, or COBRA, which, as we know, gives workers and their families who lose their health benefits the right to choose to continue group health benefits provided by their group health plan for limited periods of time under certain circumstances, such as voluntary or involuntary job loss, reduction in the hours worked, transition between jobs, death, divorce, and other major life events. There have been some major changes, mostly related to COVID, which have happened in the last couple months. Continuation coverage has undergone these changes. Ordinarily, qualified individuals were required before to pay the entire premium for COBRA coverage up to 102% of the cost of the health insurance plan. And as most employers probably know, because many of them are probably plan administrators, that 102%, the 2% covers the administration costs to administer the plan. However, in the spring and summer of 2021, and continuing at least through the early fall, COBRA premiums have been available for reimbursement for the employees who pay them from the federal government. And COBRA continuation coverage based on certain circumstances has allowed for people to reach out to the federal government and receive certain reimbursements in full and or part, as I believe, to be able to pay for their COBRA coverage. Additionally, the American Recovery Plan also contains a premium subsidy so that eligible individuals, can receive coverage for up to 6 months additional in the event of a major life event. Now, also related to COBRA, the US DOL has posted to its website 2 frequently asked questions documents on the recent updates to COBRA and the major health regulations associated therewith. Key points and takeaways from the FAQs include the following: a discussion of the eligibility based on reductions in hours, so a consideration of what the qualifying different milestones are, a way to help people figure out how to interact with DOL and continue to ask their questions during the outbreak period of COVID, a consideration and an explanation of the deadline for new election notices to employees, considerations related to the timing of participant coverage election, and information about why and how the plan does not currently require payment of the administration fee. The IRS has also gotten involved through something called Notice 2021-31 and has advised that it will provide those employers, multi-employer plans, and insurers who maintain group health plans during the pandemic with a tax credit. As I said, this is good information for employers as well. The notice that the IRS put out addresses the following: how employers can calculate the tax credit, which employers are eligible, an explanation of how the premium assistance period works, and other information that is vital to employers, plan administrators, and insurers to understand the credit.
Okay, thanks for reviewing those crucial updates to COBRA, one of the many changes that have taken place due to the American Rescue Plan Act of 2021. Also, I'd just like to remind the audience to send in any specific questions to be answered by our guest speaker right there in the questions window. We'll get to them at the end, whether it has to do with the COBRA section we just covered or something we covered earlier. Now, can we move on to some general employment law updates that aren't necessarily connected to the coronavirus response?
Sure, Stephanie. It's nice to take a break from COVID-19. I have a few to discuss. The Equal Opportunity Commission has recently released guidance for employers regarding the extension of Title VII discrimination protections to cover new classes of individuals who should now be considered to be protected by Title VII. And those are individuals who raise as their protected classification any issues related to sexual orientation and gender identity. There have been rulings that have occurred at the Supreme Court dealing with some very specific cases with employers where employees felt they were discriminated against related to something related to their sexual orientation or their gender identity. One of these cases involved a transgender worker who was discriminated against, and at that point, transgender, according to the Supreme Court, was something that should be included as a protected class. And there are many different types of gender on a broad spectrum these days. It's worth employers looking up to understand some of the language about gender, sexuality, expression, and gender identity, because the Supreme Court has really leaned in to making sure that all these individuals are protected. In addition, the federal government, the federal White House, through the president, has put out an executive order addressing government agency compliance with the Supreme Court's rulings. And we've seen a lot of executive orders that sort of lay out as an example the way that businesses should follow based on the way that the federal government is behaving. Under the executive order, federal departments and agency heads are to review all existing orders, regulations, guidance documents, policies, programs, and any other agency actions for compliance with the new understanding of Title VII. And where necessary, these entities should revise their policies to permanently eliminate discrimination on the basis of gender identity or sexual orientation anywhere at the federal level. On March 31st, 2021, the National Labor Relations Board's acting general counsel, Mr. Peter Orr, issued a memorandum entitled Effectuation of the National Labor Relations Act through Vigorous Enforcement of Mutual Aid Protection and Inherently Concerted Doctrines, a mouthful. But basically, this was guidance sent to all regional directors offering a preview of the general counsel's enforcement and litigation strategy over the coming months. This is, again, the National Labor Relations Enforcement Agency, which has been around the NLRB since the 1930s and the creation of the unions under the New Deal, and is there to now today, in its modern form, to make sure that employees' rights are protected whenever they engage in mutual complaining, and their rights are protected whenever they raise a concern. Additionally, the agency is focusing on providing additional coverage for employees who leave their jobs for up to 36 months for spouses and dependent children, also in relation to Medicaid, and then additional coverage for dependent children in the event that the child loses their dependent status, for instance, if they age out of that program. In addition to the categories of speech that have traditionally been protected and the other protected classification that we've discussed today, this is a time when we're really looking for wages, job security, and hours of employment to also be very carefully protected by the NLRB. In May of 2021, President Biden signed an executive order improving the nation's cybersecurity requirements. We're changing gears a little bit here. The order is intended to set a precedent for the private sector by mandating improved cybersecurity at the federal government level through efforts to identify, deter, protect against, detect, and respond to cyber threats and threatening actors. In the years ahead, government cybersecurity will be modernized by adopting the best security practices available advancing towards a zero trust architecture, accelerating the movement to secure cloud servers, including a software as service, infrastructure as service, and platform as service model, centralizing and streamlining access to cybersecurity data to drive analytics for identifying and managing cybersecurity risks, and investing in technology and personnel to meet modernization goals. The President's executive order also seeks to enhance the software supply chain, establish and continue a federal cyber safety review board, standardize the federal government's playbook for responding to cybersecurity vulnerabilities and incidents, improve detection of cybersecurity vulnerabilities and incidents on federal government networks, and improve the federal government's investigative and remediation capabilities.
Yeah, so lots to consider there for employers, Jeff. Thanks for covering those topics. I understand there have also been some changes to determining eligibility to work in the U.S. Would you mind covering any significant changes in this area?
Sure, Stephanie, of course. What we're going to really talk about here is I-9 compliance and switching over for at least temporary, perhaps longer than temporary, to a remote model. Every business should have a policy in place regarding, of course, the hiring of immigrant workers. Recent legislative changes have taken place to move over to remote I-9 compliance and the hiring of workers under something called the H-2B visa designation. Employers should be aware of the following. In terms of changes to I-9 compliance, the Immigration and Customs Enforcement Agency, or ICE, has announced an additional extension to Form I-9 compliance. What that means is employers who are in remote situations who've sort of stopped going over that, stand here at my desk with the HR rep while we take your documents, look at them, scan them, give them back to you, and send you on your way. That's now become a process that, due to the remote workplace situation, many employers are able to conduct by using remote resources such as secure servers and links, email, scanning, all these things that we're familiar with since many of us have been working at home over these last 2 years. So that's now something that's allowed that can be remote. It used to be in person. The Department of Homeland Security is going to extend their policy to allow this at least until August 31st of 2021. The agency has been given broad discretion to not prosecute any concerns about I-9 or anything related to the remote situation. And this is a temporary policy right now because of the remote situation, but as many employers know, the remote workforce component of their work may remain partially or completely part of how they do business. So it's also very likely that this rule may remain in place past the end of this summer. In terms of worker visa compliance, the Departments of Labor and Homeland Security have together published a joint temporary final worker H-2B visa rule. And what this basically means is that if you're an employer who works with H-2B visa individuals, which is non-agricultural guest workers, there's up to 22,000 visas extra that have been made available by the federal government since the spring. So if you're looking again to work with non-agricultural guest workers, which is a broad classification of workers, you should know that those workers may have visa availability and you may be able to bring in some qualified professionals that you wouldn't otherwise have access to during this time.
All right, and thanks for reviewing those various employment law updates that should be observed by employers. Audience members, please take this time to download your free resource if you haven't done so. It does cover the recent updates of 2021. A lot of things that we've covered today, but also a good read if that is information you need. And before we move on to questions from our attendees, remember to also get those in at the last minute here because we are rounding towards the end of the presentation. Jeff, do you have any final tips for employers based on the 2021 employment laws we've covered in the presentation today?
Yes, there are a few things that I want our audience to think about and try to remember from today's discussion. Number one, take stock of your business's bottom line operational needs versus your potential flexibility in terms of COVID-19 in order that you can understand what your regulatory requirements are as well as your flexibility. We went back in the beginning, we talked about discrimination issues and also COVID-19 workplace concerns that people have brought forward. You really need to understand as employers how far you can bend before breaking so you can accommodate the various COVID-19 related requests that may come in from your workforce. Any downtime that you have right now as an employer because of COVID-19, use this time to examine government programs for opportunities. There's a lot of grants out there, there's a lot of assistance, not just regulation like we've talked about today. If you do have to lay off employees, always be straightforward about the reason for termination and be comprehensive at the time of termination for letting those employees know what their rights are. For instance, access to post-layoff programs like COBRA, as we discussed today. Continue to review expert guidance and look for compliance with executive orders within your business. Because the executive orders continue to be drafted and used by the Biden administration, and they're relying heavily on this form of lawmaking. Maintain an open, finally, the last piece of advice, maintain an open and accepting workplace, and where possible, a knowledgeable, dedicated HR professional or someone else on your team dedicated to that type of work. To give employees with protected characteristics and needs equal access to the workplace, and also to avoid future lawsuits. Try to keep an open mind and understand that in the modern context, there are a lot of new protected classifications, a lot of new protected behaviors. And again, if you can bend without breaking, try to accommodate these workers, because it will definitely make for a more positive and certainly less litigious workforce for you going forward. Thank you, Leon and Stephanie, for giving me a chance to talk today. And thank you, everyone, for attending.
Yes, thank you so much as well. And I'll quickly ask a final poll question for our audience, because we do want to save as much time as we can for those questions. This is the last call to get those in, but we just want to know, and we'll see there, what webinar topic would you be interested in the future? Is it an EEO topic, general workplace and safety topic, wage and hour record keeping and recording topic, best practices for employee management and talent acquisition, or avoiding employment lawsuits, fines, and violations? Once again, we'll keep it brief here, because we do want to answer as many questions, specific questions that you have at the end of the presentation. So we'll let those answers fly in. Oh, we got a neck and neck race. We're closing at 50%, and I'll share the results here. It looks like a lot of you want to see avoiding employment lawsuits, which is expected. It's one of the most important aspects of owning a business, right? Other than your service that you provide. And then best practices for employee management and talent acquisition. So we'll definitely make sure that we consider those on future presentations.
Yeah, thanks, Leon. So before we end today's session, I'd just like to remind everyone that all attendees will receive a follow-up email with a certificate as proof of attendance to today's webinar. So let's take a moment to answer some questions from our audience that were submitted during the presentation. So Jeff, I'm just going to ask you a couple of questions that came through here. So we have a question our audience members asking. So they said 80% of our workforce is vaccinated. They don't want to wear masks. How can I protect the unvaccinated that do not want to get the vaccine?
That's a great question to the member of the audience. If 80% of your workforce is vaccinated and the 20% is not, this takes us back to what we said about the need to have a policy in place that's communicated about what you're going to expect. Certainly, you could make it a policy to vaccinate everyone, or you could make it a policy for everyone to wear a mask. You have those options. But here you want to do the most possible to please the greatest number of people. What I would recommend is consider the business necessity, consider the safety of all, and most likely request the 20% unvaccinated folks, if you know who they are, to continue to wear a mask. That would be an accommodation that you would provide, allowing the accommodation itself is allowing them to work, but requesting they wear the mask. Alternatively, you could choose to allow no one to wear a mask, and the vaccinated people would be, to some extent, taking that risk. But I wouldn't advise that, because that doesn't seem to be the way most guidance is going. The guidance seems to be that unvaccinated individuals who are mixed in with vaccinated individuals should be wearing a mask. So that's a little bit outside of what we talked about, but definitely have a policy in place. I would say the 20% should be asked to wear a mask. My experience so far in this issue and in labor law is that if you ask the 20% to wear a mask as the accommodation so that they can continue to work and be unvaccinated, I bet you that number will get down pretty quickly to 10 or 5%. I don't think 20% of the workforce has a protected reason for not getting vaccinated. They probably just have, they just haven't done it, or have some reason that doesn't reach the level of protected. So I would ask the 20% to wear a mask, inconvenient for them or not, and I would hope that would encourage them to go get vaccinated if they can. And the remainder should wear the mask until COVID guidance is issued more from the CDC saying that we're out of the woods.
All right, thanks for that guidance, Jeff. We have another question here. I'm just going to keep moving along. Audience member is saying, what Sorry, I was just on it there. Okay, what about an employee who says that they will not get vaccinated because the vaccine is not FDA approved, or they just don't believe in it? How could an employer legally respond to them?
I understand, Stephanie. We talked about this a little bit, you and I in the group before we gave this presentation. There is definitely a difference from having a protected reason to not get it. So we assume here that the policy is we would like everybody to get a vaccine in that question. There is a difference between having a constitutionally protected reason to not get a vaccine and just not liking it or being afraid of it. Fear is not a protected classification. Unreasonable fear even less so. If the employee doesn't want to get it just because they don't want to get it, I generally recommend not giving that employee a hard time because we want to try to accommodate the broadest possible spectrum of individuals. But again, back to the same answer, that employee is then going to have to wear a mask if they want to come to work. It's not a good enough reason to engage in the process back and forth of what's your basis, what's your protected classification, and what kind of accommodation can we provide you. Just skip right ahead to the accommodation and say, well, then you're going to have to wear a mask. I think that's the best way to go if most of the workforce is vaccinated.
Thanks, Jeff. Appreciate the guidance there. We have an I-9 question here. Audience member says, my interpretation of the I-9 update is that you would still need to review the documents in person and note it, assuming the employee returns to the office eventually when it reopens. What if the employee is always going to be remote, though?
That's a great question. My understanding is a little bit different. My understanding is that the documents can be reviewed at the front end of accepting them for employment using remote resources, and that'll stand. We can follow up to confirm if there's any sort of back end requirement, but my understanding is that you can bring them in using, remote abilities to assess the I-9 process, and once they're in, they should be in. As far as if they're going to remain remote forever, that would lend itself even more to that argument that if they're going to be remote forever, they'll never be able to come in to have the documents reviewed. And I'm fairly certain that that's the case. We can follow up with that and check the guidance, but I'm fairly certain that this remote process, once the process is covered, I-9 is considered to be satisfied and the documents are considered to be verified. There shouldn't be any back-end responsibility.
Thanks, Jeff. Now we have a privacy question here. So we have an employee that tested positive for COVID. What are the rules with letting other employees know she has it? What can we tell our clients? For example, can we say so-and-so has COVID, or should we say someone in our office has tested positive for COVID?
Right. That's a great question, Stephanie. I had a lot of clients who came to me with that earlier in the pandemic when there was a lot more fear and concerns in workplaces. The answer is, as the employer, you have certain obligations under HIPAA to not have access to medical information about people and then share it with the office. The way that this is actually handled and the way it's legally handled is that you're allowed to tell employees that they may have been exposed to someone with COVID, and then you can pick based upon how your office is structured. Do you want to say someone in your on your floor, someone in your wing of the building, someone in your department, someone in this office? Depending on how much that will single out the person, that's how you handle the problem. I apologize for that guidance being a little bit on the vague side, but every workplace is different. You have to look at the size of the workplace, and the ultimate determination is don't single out the individual, but give the employees enough information so they can protect themselves. So if you're working in an office of a few people and the office is small, then you say someone in the office may have been tested positive for COVID, or there could have been a COVID exposure in the office. We want to make you aware of this, and please act accordingly. 99% of the time, employees in these situations know who the other employee is. It becomes obvious to them when that person is sick and not at work. However, as the employer who has access to confidential medical information, you cannot by name legally show who the individual is. So make it vague, but also effective. Tell them, again, a person in your group, a person on the floor, a person in this department, something of that nature, based on whatever it will be to not single out the person.
Thanks, Jeff, so much. So we're creeping up to 11. We're going to go a couple minutes over so we can try to get through a couple more questions here. Again, any unanswered questions will be forwarded to Jeffrey via email. So moving on, a couple more COVID questions here. So can an employer ask or require proof of the vaccine?
My understanding is that would fall under the employer vaccination policy, and I believe the employer could, subject to having to keep that information as confidential as they would any other medical information. So my understanding is that they can require proof of vaccine as a private workplace because that falls under the business necessity and the safety. They can require it, but again, that information can't be shared because of confidentiality related to HIPAA, and the policy has to be applicable to all. An employer certainly would not want to be caught singling out a certain group of people or any particular person, maybe perhaps because they thought that person seemed sick, and ask them to prove vaccination. It has to be generally applied to all and noticed to all. I would err on the side of caution with that. I've heard a lot of employers are not comfortable asking for that information, but if you are going to ask for it, make sure it's universally applied to all. And keep it confidential. Sorry.
Thanks, Jeff. Sorry, I keep putting you on the spot here, but we have a couple more COVID questions, so I'm getting through them. We are hearing a lot about fake vaccination cards. Does an employer have a duty to confirm the vaccination record is authentic?
Ooh, well, I think the answer there is that the employer only has the obligation to the extent that the employer wants to fulfill their own policy. Beyond that, the question would be, if something happens to someone else and the employer is brought to task over it, if they're accused, for instance, of negligence, if they didn't have a policy that kept everyone safe, would they be responsible to finding out about fake COVID identification cards? My answer to that is going to be like any fraudulent document that a person submits to an employer. There will be an affirmative defense for the employer that somebody else committed willful fraud. So I think that the answer is overall, I hope I can give my answer on the spot. The answer is that will be an affirmative defense for an employer in the event there's a lawsuit. They were exposed to fraud. They took reasonable efforts to try to implement a policy. And then the person who provided the fake card would be the person to whom the liability shifts in the event of an incident. Or the employer could even perhaps sue that employee if they had to in a lawsuit because that employee did something that was fraudulent and willful. You shouldn't be and you cannot be faking those documents. Those are semi-official government documents. They should not be being tampered with. But if someone's tampering with them, I think it's safe to say that the employer will not be held liable for that.
Very nicely put. I have an audience member asking if this recording will be sent out to you. Yes, it will be sent out to all of our audience members or anybody registered after the webinar. Moving on, I think I have time for maybe 1-2 questions. If an employee doesn't want to wear a mask, can I actually ask them to sign a waiver at their own risk?
If an employee doesn't want to wear a mask, I think that everything that we've discussed so far today says that that can be a fair policy. I go back to what I've said right along. The policy has to be noticed and equally applicable to all. So to avoid getting into a situation where making them wear a mask goes from, because again, we can look at it a few different ways. If they choose not to have a vaccine, assuming they have a reason for it, giving them the right to come to work, but asking them to wear a mask is a reasonable accommodation. So at that point, you're providing them a reasonable accommodation to do their job. We don't want a reasonable accommodation to go and to transit into something else and become an adverse employment action. So what I mean in simpler terms is don't create a situation where that person is singled out and forced to do something that no one else is aware of or has to do. The way you avoid that is you create an affirmative policy and say to your employees, we would like everyone at the workplace to be vaccinated. Those who are unvaccinated can come to us and contact us if they have a protected reason. We'll provide an accommodation. At this point, we believe the accommodation will be to wear masks and use hand sanitizer, which are recommended anyway by the CDC. If there's any issues with wearing a mask, come to our attention, discuss it with us. Those who refuse to get a vaccine or wear masks in the workplace will be asked to sign a liability waiver. I think all that's appropriate as long as it's put into a policy and the policy is applied equally to all and noticed to all.
Thanks so much. Okay, one more question here. I'm thinking it might be a quick one. So do employers have access to a list of vaccinated employees from the CDC or in general?
That's a great question. I don't think the answer to that question is yes. I think the answer is no. From what I understand, at the agency level, the CDC, your local hospital, your state medical division, whatever division of the state government deals with medical, my understanding is that all that information is being aggregated together for government record keeping purposes to detect trends and statistics based on where COVID is, where the spread is, what demographics of people are vaccinated versus not. I don't think that's information. I know for a fact that's not information you can readily get anywhere. And I don't even think you could open Public Records Act, request it, because it falls under HIPAA. And I don't think the government, if the government's gathering it, they're gathering it for reasons that would be exceptions to HIPAA because it's a national emergency, and that gives the government a little bit of leeway there. But they're certainly not going to share it with private employers upon request. So I think the answer to that question is no.
All right. Thanks so much, Jeff. And unfortunately, we've run out of time. Thank you so much for answering all those questions that we threw at you on the spot. All unanswered questions will be forwarded to Jeff via email, and his responses will be sent to attendees in the coming days. Thanks to everyone who submitted the questions about today's topic. And thanks again to Jeff for taking the time to answer them.
Welcome.
Yes, and we enjoy hosting webinars for our valued customers, and as such would really appreciate your feedback. Please stick around a couple of minutes as a brief survey will open for you to rate what you saw and heard today. This concludes today's webinar. Thank you for attending our presentation. We hope you found the information useful in understanding critical employment law updates taking place thus far in 2021. Thanks again, Jeff, for being our guest panelist. You did an excellent job, especially in the question and answer session. And we look forward to continuing to work with Jeff on future presentations. If you enjoyed today's webinar, we invite you to view past webinars on demand at the link provided on the screen. Also, please subscribe to Personal Concepts Podcast, the Labor Law Report, for bi-weekly employment law updates, hosted by myself and Stephanie Balicki. To all of our attendees, thanks for choosing Personal Concepts as your provider of workplace compliance solutions, and have a good afternoon, everyone.